All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Morning. This is the time set for oral argument in Levine versus City of Phoenix, our civil number 15-0357. Judge Catani was supposed to be with us this morning, but he's had a family emergency, so we will muddle through without him. He will, however, be listening to and watching the audio and video recording of our argument here this morning. When you do approach the podium, please identify yourself and your clients. For the record, the recording will be available on YouTube within a matter of a week or so after the proceedings, so you can certainly check that out as well. We have read the briefs, we've been through the record, and we've conferenced the case. So we're familiar with, we think, with the underlying facts and proceedings and the issues that have been raised here on appeal. So please keep that in mind as you proceed with your arguments. Each side will have 20 minutes within which to present their arguments. Appellant may reserve some portion of that for rebuttal. It's up to you to keep track of your time in that regard, however. With that, you may proceed.
May it please the court. Your Honors, my name is Damian Meyer of Engelman-Berger. I represent the appellant, Michael Levine, who's in the courtroom here today. Mr. Levine owns several properties in downtown Phoenix. He's an advocate for the preservation of historic buildings and the proper development of downtown Phoenix. Development that is consistent with the downtown code and Phoenix zoning ordinances. Now, bearing in mind Your Honor's statement that you've gone through the facts, I'm going to breeze through those very quickly. If there's a specific fact you have a question about, please let me know. But this matter involves real property that's located on the southwest corner of Madison and First Street, across the street from Talking Stick Arena where the Phoenix Suns play. SLP, or Suns Legacy Partners, owns 6 parcels there, and my client owns real property to the south. On June 17th of 2013, SLP submitted a use permit application to develop an interim surface parking lot on its property. The City of Phoenix Planning and Development Department has a zoning process guide for use permit and variance applicants. This document is attached as Appendix Exhibit 13 to the appellant's opening brief. This guide indicates that there are 2 requirements in order to obtain a use permit. 1, no adverse impact on the adjacent property owners, and 2, that the use must be in compliance with all provisions of the zoning ordinance. In the project narrative of SLP's use permit application, it acknowledged that its proposed use of an interim surface parking lot would not be in compliance with all zoning ordinances. Under the city's own guidelines, the use permit application should have been denied out of hand at that point.
Well, Mr. Meyer, I want to ask you a question, a factual question about a statement that appeared in the answering brief and on page 7 at footnote 4, and it talked about or alluded to the difference between a use permit and the design review process, which it said is distinct and is conducted by the city's Planning and Development Department. And that I sense that that's an issue here that the appellees wish to talk about, which is how a use permit is really limited to the use, and what you're really complaining about is the implementation or the design. So at this point in the answering brief, notes that the design was presented to the Planning and Development Department and approved, and so and that your briefs did not address that. So I want to give you an opportunity to comment on that.
Sure, I understand your question, and what we need to do to address that, Your Honor, is let's take a look at what the zoning administrator and the Board of Adjustment actually did in this case, okay? And what they did was they
Before you
approved the
get
site
to
plan.
that, I guess what I really want to know is that true that the Sons Legacy Partners took this design to the city's Planning and Development Department and received approval?
Before they went to the zoning administrator?
I don't know whether it was before or after.
Your Honor, we don't know that. That argument has not been fleshed out, but I would submit to you that even if that had been approved, that only strengthens my client's case that the SLP was given a pass here. You cannot approve a use permit that does not comply with all zoning ordinances. That's what the City of Phoenix's own use permit guidelines require.
Isn't the only function of the proceeding of which you're complaining to determine whether parking is an appropriate temporary use on that parcel?
I respectfully disagree with that, Your Honor, and here's why.
Well, let's just start with this, because I'm trying to fold it back to your argument, okay? That is, the primary question is, shall this parcel be permitted to be used as a parking lot for 5 years? Am I wrong in that?
I believe that you are, Your Honor, respectfully, because I think that's the first step of a two-step analysis. Okay. No one disputes that 1204D, the land use metrics for the downtown code, says you can have an interim surface parking lot and you can get a use permit to have that parking lot.
Okay.
You can do that. But that is not the end-all, be-all of the analysis. Our position is, yes, you can have a use permit, and yes, you can have an interim surface parking lot, but that parking lot has to be in compliance with all zoning ordinances.
But is that question, I mean, you wind up with sort of a circular system of regulation that nobody can get out of, right? Because if another body has the responsibility of determining whether the exact manner of use is in compliance with zoning regulations, what is the adjustment board to do? The adjustment board, it seems to me, says, yes, this use is appropriate, provided you comply with zoning requirements, right?
Correct, Your Honor. And our position is that the zoning requirements were not complied with.
That's not within the adjustment board's purview.
Your Honor, under the statute 9-462-06H1, I believe it is. That bars the Board of Adjustment from making a change to a zoning ordinance. And when you don't enforce the standards, Your Honor, that is a de facto change to that zoning ordinance. That's been our position from the get-go. The Board of Adjustment did not enforce the zoning ordinances here. All it did was say, okay, 1204D, that's the argument SLP is making, that 1204D says interim use parking lot, we have a use permit, we're good to go. But let's look at what happened at the Board of Adjustment hearing. It wasn't a simple rubber stamp. There's 55-page transcript in the record, Your Honor. And Mr. Morris, who was representing SLP at that time, he never argued what's being argued before you now. He didn't say, well, 1204D says we can get a use permit for that, and that's the end of it. He applied much more for what is a variance. He said, you know, we have to look at a sliding scale onto what's proportionate. There has to be a balancing act. You know, what would be appropriate or what's proportionate, because this is only an interim use and not a permanent use. They acknowledged right there in their application and before the board that they were not complying with the downtown code requirements.
And what is the specific and most stark example of noncompliance?
Well, I set those forward in my brief, Your Honor, and I'd say the most specific and stark noncompliance is the failure to adhere to the 30-foot setback on Madison Street. Right now there's only 8 to 10 feet setback, and there's also trees are not, there's not sufficient trees there. I think if it's Appendix 18 is a photograph of the completed parking lot. You'll see trees that are approximately 30 feet apart. They represent they to be 10 feet apart. It's just a blight. It's just a piece of asphalt with no landscaping.
But it wouldn't be if it had a few more trees?
Your Honor?
A little bit more setback?
Well, Your Honor, it can sound trivial. I understand that, but that's the city of Phoenix invested a lot of money in the downtown code and how they want to create a vibrant environment down there. And they don't want things such as interim surface parking lots in the first place.
Let's assume that there need to be a few more trees on this parking lot in an area we've all been to. And I doubt seriously that the most beautiful tree in the world would transform that into less of a blight. But let's assume for the sake of argument that you're right. How does that, what kind of order is the Zoning Adjustment Board supposed to issue to accomplish that? Simply deny the use permit?
Deny the use permit.
Because of what? Again, I'm coming back to this circular system of different bodies considering different parts of the overall project. Somebody's got to make a decision first, and it seems to me that decision can be made conditionally. Am I...
Well, Your Honor, I would go back to the statute, 9-462-06H1, which says the Board of Adjustment cannot change these zoning ordinances. And when they approve a use permit that doesn't comply with the zoning ordinance, that's what they do.
The project. They just approved the type of use. And that, to me, seems to be within their purview, but not an approval of the entire project. They didn't issue a building permit, for example.
They approved the site plan, Your Honor, as submitted. And I believe that is Appendix 18 or 19, Your Honor. Okay, Appendix. If we go to the SLP Appendix, the answering brief on page 269, item number 2 of what the Board approved, Your Honor. Landscaping as proposed in the site plan along Madison Street and as approved by the Planning and Development Department. So, SLP brought a site plan to the use permit hearing. They brought a site plan to the Board of Adjustment hearing. They said, we know we're not in compliance with what needs to be done, but we're asking you, because it's an interim use, to not require us to meet the downtown code requirements. And that simply, it's a black and white issue, as I put in our brief, Your Honor, that you cannot grant a use permit.
Okay, but is then the remedy you're seeking the amendment of the site to conform? You want a few more trees planted?
The remedy we're seeking, Your Honor, I apologize if I stepped on.
Or is it the disallowance of the use altogether?
We have never opposed an interim surface parking lot because 1204D allows that. Okay. But the parking lot must be constructed in a manner that is in compliance with all of the downtown code zoning ordinances and the Phoenix zoning ordinances.
My question remains. Is the remedy you're seeking the installation of the additional trees, or is it?
The remedy is to modify, do whatever you need to do to bring that parking lot so it is in compliance with all of the downtown code requirements.
And I understand that, but then I have to ask, are you challenging the right proceeding in the process? Should you be challenging a proceeding other than the one that gave rise to the use permit to assure that compliance with the appearance requirements, if you will?
Your Honor, I have not thought of that specific question, but what we have challenged and what we're here challenging before you today is the decision of the Board of Adjustment to grant and affirm a zoning administrator's approval of a use permit that everyone acknowledges did not comply with the downtown code requirements is in a violation of ARS 9-462-06H1, as well as the comparable Phoenix zoning ordinance code. And I've cited the Ivankovich case in my brief, and I want to talk a little bit about that case. There's simply not a lot of case law on these use permit or variance type issues, and I think Ivankovich is a case that best guides this court. And there's two principles in that case that I believe apply today, Your Honors, and that is, one, the board cannot amend, a Board of Adjustment cannot amend or appeal an ordinance. That's not within their purview. And secondly, the Board of Adjustment's administrative discretion is limited by the narrow compass of the city code. Boards cannot arbitrarily pick and choose individuals of whom it will or will not require strict compliance with the ordinance. So what happened in Ivankovich? There was a department store in Tucson that sought a variance to build a third story on top of their two-story department store. The test for the variance under the applicable Tucson ordinance was you have to show exceptional practical difficulties and exceptional undue hardship. A variance was granted after the applicant showed that it could operate its store more efficiently and for a greater profit if it was allowed to build that third story. And the Tucson Board of Adjustment granted the application. On appeal such as this one, the appellate court reversed. It said that just because you found that the department store might be able to make more money and more profit, that doesn't meet the standard of granting a variance. And they reversed and ordered the trial court to deny that variance. So how does that apply to this case? Okay. By granting the variance, that Tucson Board of Adjustment, they violated and acted contrary to law. They didn't enforce the standards of their code.
Can you point to language, though, in the record where the Board of Adjustment here purported to grant a variance?
Your Honor, they haven't, in our case?
I don't think they granted a variance.
They did not grant, well, Your Honor.
Ivankovich doesn't seem to.
They granted a use permit.
Right.
But what they actually granted, because a use permit requires compliance with all of the zoning ordinances, it should have been denied. And they should have been required to apply for a variance, which has a different standard.
But they didn't purport to grant a variance. There is nothing in the Zoning Adjustment Board record that says a variance is hereby granted because otherwise this would be a non-complying project.
That's correct, Your Honor. And technically, that's at the heart of what we are disputing.
Suggesting that it was impliedly granted.
No, what I'm suggesting is once the use permit, once SLP stood there before the zoning administrator and said, well, here's our plan. We're not going to comply with all the landscaping and setback requirements because it's only an interim use. The zoning administrator should have said, stop. I can't grant you a use permit in that instance because you're not complying with all the zoning ordinances. You need to stop and go back and you need to apply for a variance, which has a different standard and a more difficult standard. And that process never happened. They never were forced to apply for the variance. Does that answer your question, Your Honor?
Yes, and I think it suggests that while you may have an argument here, it's a different one than Ivankovich.
Well, the way that, tying this back to Ivankovich, Your Honor, the reason that case is applicable is because granted, Ivankovich was a variance case. This is a use permit case. But in both cases, the board failed to adhere to and enforce the terms of the code. Okay? In Ivankovich, they didn't require the strict compliance with the unnecessary hardship and practical difficulties. And here, the Phoenix Board of Adjustments, they did not require compliance with all zoning ordinances as required to grant a use permit. So that's where this case effectively provides guidance to this court. And I also want to go back to the Superior Court in its minute entry denying or affirming the Board of Adjustment. It quoted, the board only approves a certain use, not a specific site plan or build out. And as we discussed, that's not what happened here. The Board of Adjustment approved the site plan. I want to save a few minutes for a rebuttal, Your Honor. So I have 3 minutes left, and at this time, I will yield the podium.
Thank you, counsel.
Good morning, Your Honor. Patrick Paul, on behalf of Appalachia Sons Legacy Properties, together with my colleague, Paul Lee, on behalf of the City of Phoenix and its Board of Adjustment. This appeal is not about whether an interim use parking lot is permissible in downtown Phoenix. It is permissible. Rather, this appeal is about whether the board's grant of a use permit to operate, maintain such a parking lot was arbitrary, capricious, or an abuse of its discretion. Judge Cunanan concluded that the board's decision was appropriate and consistent with its authority granted to it by both state and city code.
Well, Mr. Meyer was just telling us that, in his view, Judge Cunanan misstated the situation when he said that the board did not approve a site plan, when he says instead that the board did exactly that. So and that runs afoul of subsection B of this particular provision. Could you comment on that?
Subsection B being compliance with law?
Right.
Yes, Your Honor. That issue wasn't before the board. What was before the board was whether the use requested was appropriate and otherwise legally permitted. In assessing that, the board does need to look at adverse impacts, which no longer appear to be an issue, and also whether there's compliance with law. Part of that analysis is to look at what was before the board, which was a proposed site plan. How might it look? How might it be? Now, when the board motioned and unanimously voted in favor of the use permit, it had three stipulations, one of which did specifically cite, as Mr. Meyer suggests, the proposed site plan, but it asked for and it contemplated further dialogue and follow-up, final design and review with the City of Phoenix Planning and Development Department.
Was the site plan ever approved?
It was not. The site plan ultimately was approved, Your Honor, by the City of Phoenix Planning and Development Department.
And was that after the use permit hearing?
Yes, Your Honor, and that's sort of the ordinary course. It wouldn't make a good economic sense to either use of city resources or that of a property owner to go through full design review, architectural approval, and the like before knowing whether the proposed use here in an interim parking lot would be permitted.
And then just a related question, because I couldn't figure this out candidly from the briefs. Did the appellant here have a remedy, an administrative remedy, following the approval of the site plan by the planning department?
There are certainly a series of possible remedies, and one of which could be to challenge compliance with the use permit itself. One of which could be to argue that the city and the Board of Adjustment and this property owner are or were non-compliant with law and aren't presently compliant with law. There are certainly remedies available outside of this forum. But what I'd like to do, if I could, is to try and focus the court's attention on what was before the board, because what was before the board wasn't whether there was compliance with a final to-be-approved site plan. It was whether the use requested is permissible, and if so, under what stipulations. And the board does have discretion to grant those, to issue those stipulations, to require compliance with them. And certainly one of those did relate to landscaping. The Ivankovich decision that is relied upon by appellant here actually requires a presumption in favor of the board's decision, a presumption of validity, and that one challenging it is met with a heavy burden of establishing it to be somehow against the evidence before the board. In assessing the validity of the decision, Judge Cunanan isn't permitted to substitute his judgment for that of the board, and his review was limited to the evidence that was before the board. Now, it is argued that the board's use permit decision allowing interim parking somehow violated the legislative authority that's prohibited to the board in both state and city code in 462-06H and its corollary at 303B2. And yet we submit that the board's decision here simply was not a legislative act, but rather that approving the use permit was a permissible action by this quasi-judicial board, and that it should be upheld and must be upheld if there is credible evidence to support it.
Is it your contention that the proposed site plan complied with the zoning ordinances or not?
It is our contention that there was, that at the proposed level and at the level now, there is compliance with the city, with the downtown code.
What about the trees?
So Your Honor, the challenges involve setback and landscape and shade and materials. And what's missed here is that 1204 sets forth a myriad of possible property uses subject to a series of mechanisms to get there. So if, for example, there was a desire to have permanent parking downtown, we know that that's not permitted. You can't do that. It is not allowed by law. But, so you don't get to the level of trees and setbacks and the like. At the interim level, though, the city's interpretation of 1204, which itself is entitled to great weight, then allows, okay, if this is permitted, and 1204 says it is, and now we have a use permit, then the broader sections of the code of 1201, of 1207, of 1224, these sections themselves allow flexibility and discretion to the city's planning and development office in approving these uses. So, for example,
let me ask you, when the site plan was approved, was it accompanied by a variance or a determination that the site plan was compliant?
Judge Schwartz, are you asking final approval by the City Planning and Development Department? Can you restate the question, please?
Was there a determination that the site plan was compliant with zoning regulations, or did final approval require a variance?
Final approval did not require a variance. Of necessity, the City Planning and Development Office would have determined that there was compliance with the downtown code. Now, incumbent in that determination, no doubt, was an assessment of flexibility that needs to be built in on things like setbacks and the like as we anticipate further growth in the city, so that a downtown parking lot might become one day a cancer research facility or an academic law school or something else, so that we can see some growth, some anticipation that is not presently possible due to reasons outside of the city's or the property owner's control, but that one day might be, and that provided that interim use is then compliant with the city's longer-term goals. And there's a leash, and that leash expires here in 2 years. In 2 years, something has to happen to this property. It cannot continue forever as a parking lot. And a decision, Your Honors, that would be in Mr. Levine's favor would have the impact of really usurping the power and authority of the city's planning and development office, and instead placing that authority back upon the citizen board in a time and place that is chronologically inconsistent with how development occurs in this city. I think it's important to note the flexibility that both 1207 and 1224 allow as the city sees continued growth and development consistent with the plan that it is thoughtfully considered and is consistently approved in evaluating projects like this. We maintain, Your Honors, that the record here is clear, that a request for a use permit was properly made by Sons Legacy Properties, was properly considered by the zoning administrator and its board of adjustment, and was ultimately properly granted. And the results of the last 6 challenges are consistent. We don't believe there is any ambiguity in the statute utilized by Mr. Levine, but to the extent this court might find there to be some ambiguity, the court in Cubby directs that such ambiguity must be decided in favor of the property owner, because zoning ordinances by their very nature are a derogation of common law property rights. And in this instance, that property owner is Sons Legacy Properties. Happy to take additional questions.
Thank you, Counsel.
Thank you.
Your Honors, if we accept the argument that compliance with 1204D, and that because the matrix says that a use permit for interim parking is allowed, and that ends the analysis, then there's two things that this court should consider. First, that's not what happened. There was a 55-page transcript at the Board of Adjustment appeal hearing where SLP, the sons, were pleading and arguing with the Board of Adjustment, well, we're not going to do all that's required, but we're going to do this on the outside because we can't do anything in the middle. We have to balance it because it's interim use. We have to have certain trade-offs. That's not allowed. And that wasn't argued. That didn't happen. That's not how this all occurred. And second, if SLP is successful with this argument, it's going to set a concerning precedent. If that's the case, all any developer will have to do to obtain a use permit for an interim surface parking lot is just cite the 1204D. That's it. They don't have to do anything. They don't have to pave it. They don't have to plant a single tree. They don't have to do anything to deal with heat and all that stuff. All they have to do is say 1204D. That allows me for a use permit board, so please rubber stamp that application.
I think you may be overstating the authority of the board. The board doesn't issue building permits. It doesn't and didn't here issue an approval of a site plan. It can't preempt other regulations relating to PM10, for example. It can't. It just doesn't have this broad, overarching power to undo all other rules governing the use of land. I think you're giving it more credit than it deserves.
And, Your Honor, I would respectfully point out to the court that the Board of Adjustment in this case did approve a site plan. They took that action. They listened to an hour.
Why did the site plan get approved again?
Your Honor, that's a question I don't know the answer to. But I don't think the city planning and development folks are going to undercut the Board of Adjustments. But what? I
don't think SLP would have gone for a second. There's no joy or profit in going through these proceedings. Why did it go to get its site plan approved by a different body if it already had it approved by the Zoning Adjustment Board?
Your Honor, I can't answer that question, but what I can tell you is the Board of Adjustment held a hearing where it listened to SLP state over and over again that it was not going to comply with the downtown code requirements. And the statute that we've cited to you says the board cannot grant a use permit or approve a zoning administrator's grant of a use permit when it's going to violate and not comply with the zoning ordinances.
Is it possible, though, that they're right and that the Zoning Adjustment Board's action did not constitute a site plan approval and that was accomplished in a different forum?
Your Honor, again, we can't answer that question because we know that the Board of Adjustment approved a site plan. That's what happened. That's what the record tells us. Any other questions, Your Honor?
No. We appreciate the arguments here this morning as well as the briefs that were filed in this matter. We will take this matter under advisement and issue a written decision in due course. We're going to take a brief recess to allow counsel for the next case to come forward and get set up for the next argument. Thank you.